And then finally, I moved to EW, right? So ZG and EW against Ireland. Look, I set the facts out in the first video. I'm pressed for time now, as you can see, so I'll just give a kind of a brief overview and just give you a flavour of the case for you to read it yourselves, and particularly the disagreement between the Chief Justice Donald O'Donnell and Ms. Justice Aileen Donnelly. So EW was a 14-year-old boy when his mother was murdered. So EW and his mother lived together as a single parent family in a rental apartment in Dublin. She was the statutory tenant, in other words, under Section 39 of the Residential Tenancies Act 2004. She was protected as a tenant, whereby it significantly limited the capacity of the landlord to terminate the tenancy, let's say. So the idea in legislation is that normally, on the death of a tenant, a statutory tenant, the statutory tenancy terminates, and the landlord can then proceed to enter into another tenancy with another tenant, if you like. But it does set out certain limitations, whereby, and I think there are four perhaps, if you are the spouse of a, or civil partner or whatever, of a statutory tenant, and you're living in the apartment at the time of the death of the statutory tenant, then you succeed to the statutory tenancy. Similarly, if you were the parent of the statutory tenant, and similarly if you're a child, but a child over the age of 18. Now, of course, that had the effect of excluding EW. He couldn't succeed to the statutory tenancy because he was only 14. And I suppose this was an extraordinarily traumatic time in EW's life, aside altogether from his living arrangements. But now, on top of that, the idea was, or the argument was, he was out on his ear, or he was uprooted from his home and community, in the sense that he would have to, or alternative accommodation would have to be found for him now, and he'd have to start afresh in a new school, potentially a new community, so on. And the argument ultimately was, or boiled down to the idea that this was a breach of his Article 40, Section 1 rights. Now, there were other arguments, which I won't get into, other constitutional arguments, I should say, which I won't get into here, but essentially the argument was, as far as we're concerned, that treating him as a 14-year-old child in this context differently from how an 18 or 19 or 20-year-old child of a deceased statutory tenant was irrational. In fact, the argument was slightly more complicated in that the counsel for the applicants for EW argued that the rationality test shouldn't be the test because age was an immutable human characteristic. In other words, you couldn't control your age, a little bit like you can't control your sexual orientation or your ethnicity. And so it was a suspect classification. And so therefore the threshold for intervention should be lower. Now, essentially, the judges in the dissent agreed with that argument. Ms. Justice Aileen Donnelly agreed with that submission, and Mr. Justice Gerard Hogan concurred in Ms. Justice Donnelly's judgment in that respect. Whereas the majority, there was a case split the court, there was a 5-judge court, it was the Chief Justice, Donald O'Donnell, wrote the judgment for the majority. He rejected the submission that age was a, quote, suspect classification. He said, look, yeah, sure, age is an immutable human characteristic in the sense that you can't control your age no more than you can control your sexual orientation or your ethnicity. But he said it's not, age isn't a human characteristic that has historically attracted or been the subject of prejudice or stereotyping. And so therefore, it shouldn't be amongst, or deemed to be amongst, the designated suspect classifications, if you like, so the regular rationality test applies. Whereas Ms. Justice Donnelly was of the view that this was a suspect classification. She actually introduced a new phrase to capture the idea, a classification of concern she preferred. Now, you might remember that actually Isot O'Malley didn't quite like the phrase suspect either. I mean, it's an American phrase, and classification of concern is maybe a more apt phrase in the sense that it just doesn't have the same connotations quite, and it's more readily applicable in contexts outside of, let's say, racial hatred, for instance. But she designated age as a quote-unquote classification of concern, thereby she would have lowered the threshold for judicial intervention. But as I say, she was in dissent on the point. As for the question as to whether the classification was a legitimate one, or the exclusion, if you like, of 17-year-old and younger children was irrational or rational, well, the majority, that is to say O'Donnell and his two colleagues that formed the majority, were of the view that it was not irrational. In fact, they said this age classification in property and housing law is perfectly normal and legitimate. It was based on a simple judgment that the Oireachtas had made that people who were entitled to succeed to a tenancy would have to be adults. Whereas Ms. Justice Donnelly was of the view that it was irrational for reasons already kind of gestured at. But I suppose fundamentally she kind of looked at the purpose, what she saw as the purpose of the legislation. She framed it as concerned fundamentally with providing security of tenure for tenants. And she says in that context, well, then it kind of makes no sense to protect children of statutory tenants who are aged 18 and older and not protect children who are aged 17 and younger in that context. Now, of course, Mr. Justice O'Donnell frames the purpose of the legislation in a different way. I won't get into that, but that's actually quite important, and you can see that for yourselves because it's very explicitly done by the Chief Justice. But I do think Ms. Justice Donnelly's judgment, while I'm not ultimately probably persuaded by it, I do think it was very, very compelling. And I think the reasoning was very, very illuminating. First of all, very insightful, but also illuminating in the sense that it kind of sheds light on how it could be that this rationality test isn't actually as high as we might, or as insurmountable as we might think. Now, of course, bear in mind that what's informing her take to some extent is that she thinks age is a classification of concern, and therefore the threshold for intervention is lower. And it's also somewhat complicated for those of you who read the judgment by the fact that she's also drawing on our other provisions of the Constitution, Article 42A in particular. So, look, an interesting judgment. It won't be, well, we'll see. Maybe Miss Justice Donnelly's dissent could be influential into the future. I think Donnelly, the Donnelly and Minister for Social Protection case, and perhaps to a lesser extent the O'Mara judgment, they're the big judgments for Article 40, Section 1, in the sense that they really set out and develop um, the kind of jurisprudence in a kind of a novel and comprehensive way. And I think they are likely to govern how things go over the next decade or so.